Well, we are very, very happy to have Jason with us again. And you've probably heard Jason before. He is presented before. I think he presented last year. He presents a lot for us, and we're hoping we can get him to present again later this year. But with COVID over the last year, as employers, I'm sure you know that there have been many, many legal issues or many different issues related to COVID that, and these things just seem to keep changing. And now we have a new administration, and I'm sure there's going to be more legal questions. And so Jason is going to help us understand some of that today. We're really honored again to have Jason with us. Jason is an attorney and partner with Folston Siefken, practicing in the areas of employee benefits, taxation, healthcare, and employment law. Jason is also on our advisory council for the Business Group on Health. He's been a really active and very, very supportive and helpful member to us, being an attorney that can help the organization and has for many, many years. So we really appreciate you speaking with us again, Jason, and I'm sure that you have a lot to share with us. So anyway, I'm going to turn it over to you.
All right. Hey, thanks a lot, Shelley. Let me see if I can share my screen here and get the right presentation up. Just give me a second here. All right. Can you see the slides?
Yes.
Excellent. And do they move when I move them here? Let's see.
Yes.
Perfect. Okay. All right. Well, welcome everyone. Thanks for attending today, and we'll do our best here to sort of get you up to speed on the latest and greatest as it relates to employer-sponsored health benefits in particular, and some of the legal issues related to that. We've only got 20 or 30 minutes here, so this will necessarily be pretty high level, but should at least give you a flavor of what some of the issues are that we're seeing and things that we're thinking about right now. So I'll dive on in, and let's start by talking about vaccines, in particular the COVID-19 vaccine, certainly very much in the news, on everybody's mind here the last few months. What I wanted to talk about is sort of what our requirements and options are from an employer perspective as it relates to the COVID-19 vaccine. First, in terms of what employers are required to do, employers, I'm sure all of you, sponsor a group health plan. Most of those plans are going to be non-grandfathered plans that are subject to the Affordable Care Act mandate to provide preventive care benefits without any cost sharing to participants. So things like immunizations and annual physicals and other well care type benefits are all within that. The federal government has updated those requirements, the ACA requirements, to specifically incorporate coverage for the COVID-19 vaccine, and to do it on a much more accelerated schedule than we would normally see with new preventive care items that come into the marketplace and that receive a recommendation from the CDC or other recommending agencies. The net effect of this is that essentially now, and as of about 45 days ago, pretty much all group health plans, including employer-sponsored plans, are required to be covering the COVID-19 vaccine and related administration costs without any cost to the participants in the plan. Now, as you may know, the vaccine itself is actually, there isn't a cost for that right now. The government is funding all the cost for the vaccine, but often there is an administration charge. A nurse or pharmacist or somebody has to deliver the injection, and so that's essentially the cost that plans are covering. A couple of things that are slightly different about the way the COVID-19 vaccine coverage works than other preventive care. One is that we're required to cover the COVID-19 vaccine both in network and out of network. Typically under the ACA preventive care rules, plans may cover out-of-network care, but are only required to cover in-network care without cost sharing. For the COVID-19 vaccine, during the duration of the public health emergency, which is a determination made by the Secretary of Health and Human Services, the vaccine has to be covered without cost, both in network and out of network. And to ensure that that your members, your employees have reasonable out of network coverage available to them, plans are required to reimburse out of network providers not less than a reasonable amount. And the federal government has said we can look to Medicare reimbursement rates as a sort of a floor for what the minimum out of network reimbursement would be. For you on the sort of front lines, this all may be happening more or less in the background. A lot of this is being, sort of managed by the TPAs and insurance carriers and the others that sort of manage the, the back end of group health plan administration. But I thought it might be helpful to at least sort of understand what was going on and what your employees may be seeing with respect to their health insurance coverage. Grandfathered plans, to the extent that any of you have still a plan that meets the requirements to be grandfathered from the ACA mandates, or at least certain of the mandates, including preventive care, they are not required to comply with this rule because this applies through the preventive care mandate, but are certainly encouraged to do so. And I think that the plans we've encountered are all wanting to cover the vaccine to the extent it's available and people are willing to take it. All right, so that's what you're required to do. The action, the big questions that we seem to be getting more of are what are we permitted to do as a result with respect to the COVID-19 vaccine. And by the way, of course, all of this is kind of premised on the assumption that the vaccine is going to be available. Up to this point, it really hasn't been broadly available outside of the healthcare provider context and some other sort of limited context. But assuming that this is going to continue to sort of grow and become more available, the questions employers are starting to ask are, what could we do here in terms of trying to encourage or require our workforce to become vaccinated? One option is to treat the COVID-19 vaccine much like other types of traditional wellness program benefits, such as the flu vaccine. So I'm sure many of you, every year for years have had sort of a flu shot clinic or other opportunity where you've encouraged your employees to get a flu shot. Maybe you pay the cost of that, or maybe you provide some incentive if they get that and have the cost covered through the health plan or whatever their insurance may be. We think that same sort of model and approach is permissible with respect to the COVID-19 vaccine, and many employers are thinking about doing that, including potentially offering some sort of modest incentive for employees to obtain the vaccine. We've seen people thinking about things like, offering a gift card, $50, $100, something like that. Maybe offering an extra half day or day of paid time off. Maybe offering some other sort of similar wellness type incentive to encourage employees to obtain the vaccine. We think that's okay. That there is some, concern if you were going to say, hey, we'll pay you $5,000 to take the vaccine. Maybe that's no longer a sort of voluntary vaccine program, and that may raise some other issues you'd have to think about because nobody in their right mind we'd have to think long and hard about turning down $5,000 to not take the vaccine. But in any case, that's not what most people are thinking about, and so certainly something modest and reasonable seems to be okay. There is a question, and by the way, this has been the case with flu shots and other similar benefits sort of forever, but sort of easily overlooked. And the issue is if you are offering a sort of direct to the employee's medical care or healthcare benefit, like a vaccine, immunization, what have you, that is itself a sort of health plan, and you may be offering it to more people than are just covered under your traditional health insurance plan. Well, anytime you offer a health plan to employees, that potentially triggers a number of compliance obligations, the requirement to have a plan document and summary plan description under ERISA, the requirement to offer COBRA coverage to people that have had COBRA qualifying events, and so on. So we always take a step back and think about, if is this benefit, this new sort of healthcare right that we're offering our employees, does this create some kind of a mini health plan that's going to trigger these other compliance obligations? Without dragging you through all the gory details of the analysis on that. As a general rule, we think this probably doesn't create a separate health plan so long as it's offered on a sort of limited basis, one time only or some, close cousin or version of that. Obviously, the COVID-19 vaccine is kind of a two-part, at least at this point, and maybe multiple boosters as additional strains of the virus are identified, but at least a two-part, so it's not a true sort of one and done kind of thing, but offering, we think, the vaccine as it's intended to be administered, and not sort of offering it on a continuous basis as part of a sort of a mini on-site health clinic type benefit. That's probably enough to keep you from creating a separate group health plan, but it is sort of a matter of degree, and so you would want to be careful if you start to drift into essentially setting up an on-site primary care clinic at your place of employment, where employees can get the COVID-19 vaccine and other types of primary medical care, such as immunizations and physicals and that sort of thing. What about requiring your employees to be vaccinated? Again, this has gotten a lot of press and a lot of thoughts gone into it. The short answer here, it's kind of nuanced, but the short answer is that you can, in fact, require employees to be vaccinated, subject to providing accommodations for employees with a disability that would preclude them from safely taking the vaccine, and employees that have a sincerely held religious belief, and therefore, religious discrimination protections would allow them to opt out of taking the vaccine. So, subject to those qualifications, it appears to be the case that you could require your employees to be vaccinated. To be honest, I have not encountered a lot of employers that are really thinking seriously about this. Certainly, many employers are wanting to strongly encourage their employees to become vaccinated, and thinking that that's good for the workforce as a whole, and for customers and anyone else that employees might be coming into contact with. But there are some practical issues, of course, beyond the legal issues in sort of mandating the vaccine, including, can you even have access to the vaccine? We'll assume, as I said earlier, that will happen eventually. But just the sort of, how much do you want to sort of be at war with that faction of employees? And there will be a few that, for whatever reason, just can't get comfortable, notwithstanding that they may have no sort of medical or religious or other reason that they don't want to take the vaccine. So there's some kind of pros and cons and things to think about there. But bottom line, if that was what you wanted to do, we think you've probably got the authority to do it. All right. We wanted to have a sort of interactive polling question here, and I thought the vaccine itself might be a good place to sort of dive off into a sort of to get some feedback from you. So, what are you thinking in your organization? And obviously, this is kind of fluid. Again, the vaccine's not broadly available to everyone, but what's your sort of current plan regarding vaccination of your employees? Are you thinking mandatory? Are you thinking encouragement? So voluntary, but maybe incentivize. Maybe we're just going to have a broad, sort of campaign encouraging people, but not incentivize them. Or maybe we're just going to sort of stay neutral and let it all work out. What are your thoughts? And it looks like we're getting some good responses here. Kind of leaning toward the voluntary, not the mandatory. In fact, I don't see anybody that is currently thinking mandatory, which again would be consistent with what we've sort of encountered with the clients and employers that we've been talking to. All right. Looks like this is kind of winding down, so we'll go ahead and share the results there. And there you go. Most of you are thinking we'll encourage our employees and not necessarily incentivize them, but a few in those other categories other than mandatory. So thanks for your input on that. I hope that's interesting to you to see what others are thinking about as well. All right, let's kind of shift topics, move ahead here, and talk about a few other things.
Hey, Jason.
Yeah, go ahead.
I'm so sorry to interrupt you, but
No.
I had a question I thought was probably the timing right now.
Sure.
Some reporting has said that employers can't require the vaccine because it is under, quote, an emergency use authorization. Is that incorrect?
Yeah, the guidance we've seen doesn't sort of differentiate between requiring a vaccine that has a a true authorization from the FDA as opposed to a vaccine that's just under an EUA. I guess there's a question about whether there's some difference in the safety or efficacy of the vaccine, depending on the category that the FDA has sort of approved it in. But the guidance from the EEOC, which is kind of the primary guidance on, what you can require of employees from a sort of vaccination and medical examination perspective, doesn't differentiate based on the nature of the type of authorization. So we're not seeing that as a distinction. Maybe that would factor into your consideration of whether it makes sense to be requiring the vaccine, but I don't see that as a true legal requirement.
Great, thanks.
Good. Yeah, good question. All right. Any other questions or thoughts on vaccine before we forge ahead?
Nope.
All right. The outbreak period. Love the term. Hate the problems that go along with it. Hopefully, none of you have had to grapple with this too much. But just to refresh your recollection, this refers to a piece of guidance we got from the IRS and Department of Labor in the spring of last year, late spring of last year, that essentially said for certain types of deadlines or elections that have to be made in connection with employee benefit plans. So think about things like COBRA elections, COBRA payments, exercise of special enrollment rights, following a birth or marriage or something like that. That all of those deadlines are suspended during this period that's defined as the outbreak period, which is really the period beginning March 1st of 2020 and ending whenever there is an end to the national emergency. Now that's slightly different than the public health emergency I mentioned earlier, but essentially the president has to declare an end to the national emergency, and then after that there's another 60 days potentially that ticks off, and that's the end of the so-called outbreak period. Nothing really new has happened on that, except that we're still in the middle of the outbreak period. The president has not declared an end to the national emergency, and unfortunately that does not appear to be near in sight. But what is coming up, and what I think had not been fully contemplated at the time this guidance was issued, is that it'll be almost a year that this outbreak period has been in effect here at the end of next month. And the statutory basis that the IRS and Department of Labor were relying on to sort of suspend these guidelines, these are legal requirements. These are statutory guidelines established by Congress, and normally an administrative agency wouldn't be able to just say you don't have to comply with the law. But there is a specific statute that says, well, in the case of a national emergency, the IRS and DOL can, for up to 1 year, suspend the running or the performance of some act that's subject to a deadline. Well, we're getting to the end of that year, and so now we're starting to get questions again about what happens when we get to the end of that year. Does the authority to suspend these deadlines run out, and therefore it's going to go back to normal? Or do we end up with this sort of rolling 1 year? Well, for everybody that had a COBRA event, on or after May 1, they've still got until the end of April. And for everybody that had COBRA in June, they're good till the end of next May. And that could obviously get very complicated. Short answer on that is we don't know, but I'm expecting to see some clarifying guidance on this in soon, probably in the next few weeks, because we're running up against that deadline. And so there's some questions there. So I don't know what the answer or outcome on that is going to be, but I wanted to mention it just so you're sort of watching for that and knowing that there may be some movement there here in the next month or so. Okay, let's shift gears again and talk about flexible spending account relief. This is specific to some guidance, well, actually a legislative change that was tucked into that massive piece of stimulus and funding legislation that passed very late in the year last year, very end of 2020. Buried down in the bowels of this piece of legislation was a little provision related to flexible spending accounts, and specifically healthcare and dependent care flexible spending accounts. And this guidance provides a potential relief to help out employees who have unspent amounts in their flexible spending accounts, presumably because they weren't able to use the money in the way that they expected to be able to by reason of the pandemic. So if somebody might have elected to put $5,000 into their dependent care spending account, thinking that they were going to be paying for daycare or after school care for their kids last year, and then everybody has been working from home perhaps since since March, and so they haven't needed daycare or haven't been able to access daycare because the daycare facilities or providers were closed. Whatever the case might be. Similarly, for health FSAs, people might have put their 2750 aside, thinking they were going to get LASIK surgery or have some sort of medical procedure or care that they haven't been able to have or haven't been able to have at the same level that they expected, and so they may have unspent amounts. That, and for those and other reasons, other use cases or scenarios, we're seeing lots of situations where employees have these unspent balances in their FSAs, and so this relief is designed to allow employers to let employees hang on to that money that might otherwise be forfeited. And broadly, the relief falls into kind of four categories, which I've summarized here. One is the ability to offer sort of an unlimited carryover or 12-month grace period. So what we're talking about here is you get to the end of, say, 2020, and somebody's got an extra $2,000 left over in their account. Normally that would be forfeited, or you'd have a couple of months of grace period to use up whatever you could, or maybe you could carry over 500 or 550 if it's a health FSA. But otherwise, the general rule would be that money just gets forfeited once it can no longer be used. This would allow you to sort of give people the option to carry all of that over into the next plan year, not have a forfeiture of the money. Now, there are a lot of sort of questions and nuances around how and why you might want to do that or not. But that's the idea behind the relief: prevent people from having to lose that money and let them keep access to that in addition to whatever new money they want to put into their spending accounts for this year, for 2021, or however the plan year may lay out. So that's one category of relief. Another is kind of narrow, but it affects situations, and this is specific to health flexible spending accounts because this rule already exists for dependent care. And this involves people that lose participation in the plan in the middle of the year. Typically, we're talking about somebody who terminates employment in the middle of the year, although it could be somebody that reduces their hours below the minimum eligibility requirement. This rule would let them continue to have access to their account balance post termination and spend it down. They can't sort of put more money into the account, but to the extent they're continuing to incur reimbursable expenses even after they have terminated employment or participation in the plan, they could continue to have access to that balance through the end of the year. So again, prevents a forfeiture of money they hadn't been able to use up to this point. So that's the second category. Third category, if you try to read anything about this, it's almost impossible to figure out what Congress was really saying here. But the idea is for dependent care reimbursement accounts, normally you cannot reimburse expenses for children for dependent care once they have turned age 13. That you can do it up through age 12, and then when they turn 13, they're too old, and that's no longer a qualifying expense. High level, this relief would allow you to let expenses for 13-year-olds continue to be reimbursable as well. So again, it just sort of gives an employee, maybe a little bit more time, potentially up to another year, to be reimbursed for expenses that they wouldn't have otherwise thought they might have been able to be reimbursed for. And then finally, there's some relief with respect to elections. And we had a sort of mini version of this in the middle of the year last year based on some IRS guidance. This is kind of another option to give employees a second bite at the apple during the 2021 plan year, at least some plan year that ends in 2021. This is a chance to come in and sort of readjust their contributions to their spending accounts. They might have elected to put more in than because they thought they were going to be able to use it. And now, as a result of the pandemic, they're thinking maybe they aren't. The other reason they might need this change is that they didn't know that this new rule on being able to carry over your unused balance was going to be available. And so we might want to give them a chance during 2021 to adjust their new contributions because they have that extra carryover amount. So those are the categories of relief. There's lots of other details and nuance that I won't spend the time to go through at the moment. But know that if you want to add this to your plans or some version of this that it's all voluntary, not required, and you can kind of pick and choose how you want to roll that out. Whatever you do will have to be folded into your plan through a plan amendment that doesn't have to be adopted and finalized at least until the end of this year and maybe later. There are a number of questions, so we're expecting to get some guidance from the IRS hopefully very soon to kind of fill us in on the details about how all of this is supposed to work. But that's broadly what this relief is about. And I think you'll be seeing and hearing more about that in the coming weeks and months. Okay, something totally different, but also directly related to employer health plans. This is not pandemic related, and in fact, it's sort of something that was a regulatory priority during the Trump administration, a new set of rules that was finalized. It kind of got a boost, frankly, out of that stimulus legislation that was passed at the end of the year. Many of the things that showed up in these regulations I'm going to talk about were sort of reaffirmed or added in statutorily as part of the legislation that was passed at the end of the year. But the idea here is to try to provide through some mandatory reporting by health plans and their sort of service providers, try to provide greater transparency to both individuals who are covered under a health plan as well as kind of the public in general around costs that might be incurred related to expenses that are covered under the health plan. And so there are really two categories to this. One sort of set of transparency rules that relates to individuals who are covered under a health plan, and then a second category that relates to public disclosure of pricing information. As it relates to individuals, these rules take effect not this year and not next year, but really not until 2023. But the idea here is that we want to give an individual who is contemplating some sort of healthcare service the ability to find out in advance what it's going to cost them, or get an estimate of what it's going to cost them out of pocket to have that procedure or that medical care service provided to them. If you think about an EOB, an explanation of benefits, which is typically issued, after a healthcare service is received and a claim is submitted to a health plan, and the plan adjudicates the claim, and it says, well, this much goes to copayment, and this much goes to deductible, and this much is an agreed write-off, maybe because it's an in-network claim, and then here's the amount that we'll pay the healthcare provider. That's essentially what we're talking about here, except the individual is supposed to be able to get this on the front end before they've actually had the healthcare service, and they're supposed to be able to do it just by going to a website and sort of clicking in what it is that they're planning to do and where they're planning to do it, and then getting a report or an estimate on what their cost sharing exposure is going to be. Obviously, there's lots of details and questions around how you really do that from a functional or administrative perspective. From an employer's point of view, I think the good news there is that this is going to fall largely on the TPAs and insurance carriers to figure out how this works mechanically. But just know that that's going to be coming and sort of on a timeline of here in the next couple of years. Similarly, then there are these rules I mentioned that apply to public disclosures, and they actually go into effect sooner at the beginning of next year. And this is going to be a requirement for health plans to publish to the internet in a machine readable file. So think about some sort of an Excel file or other file that a computer could scan and could interpolate that data. Required to post by January 1, 2022, and updated on a monthly basis, at least 3 files that provide information about what the health plan is actually paying in terms of prices for healthcare services. And there's supposed to be a file for what the plan is paying in network. So the in-network rate file, these are the negotiated rates that will be agreed to with the network providers. Second file, which relates to out-of-network coverage, the so-called allowed amount file. What is a plan actually paying for out-of-network care? And then a third file related specifically to what's being paid for prescription drugs. And the big picture of the idea here is that by making this data publicly available, those who are interested in sort of crunching that data, playing with that data, analyzing that data, can go out and grab that and hopefully turn that into to usable information that allows people to to shop for or compare the cost of coverage. And I think ultimately the goal would be that some healthcare cost decreases are seen by virtue of those reimbursement rates being made public. There's a lot of tension behind the scenes about what healthcare providers and payers, sort of think about having to disclose all of this information. So I think it's not a foregone conclusion that this is absolutely going to happen. But anyway, that's what these rules are about, and I think we'll be seeing more as we sort of push through the year this year about how that's actually going to be implemented and what it's going to look like. But again, just know that's coming. I don't think from an employer perspective it's going to have a lot of requirements from an administrative or compliance sort of perspective, but it's more, like I said, something that's going to be happening in the background and may ultimately have a favorable impact on costs that are being paid by employer-sponsored plans. All right, something else that's new. This was in, again, the year-end stimulus legislation. Some rules related to avoiding surprise billing, or essentially balance billing, that your employees or members might experience if they are receiving care from an out-of-network healthcare provider. And specifically, the idea here is to try to prevent individuals from incurring or encountering surprise billing in situations where they don't really have a lot of choice about their selection of the healthcare provider they are seeing. So this relates specifically to out-of-network services provided for emergency care, out-of-network providers that provide care at in-network facilities. So think about, I go to a hospital that I think is in network with my plan, and that's where my surgeon is, but the anesthesiologist and the radiologist and other people that might be involved in my care and that I don't get to pick may not be in network, and so that's another setting. And then air ambulances is the third category, which if you haven't encountered those, the costs there are just quite astronomical, and they're all out of network, by the way. They refuse to join networks and agreed and negotiated rates. So anyway, that's what these rules are about. What you should know from a health plan perspective or employer perspective is that it's a little bit of a two-way street here. These rules, on the one hand, preclude the out-of-network provider from balance billing the member. So there's a little bit of a kind of a stick approach, but there's also a little bit of a carrot approach in the sense that we're going to require the health plan to pay sort of a minimum amount for this care, so that the providers aren't completely left out in the cold, and that the members aren't stuck paying sort of out of network cost sharing. So for example, in these scenarios that are defined by this legislation, the plan is only going to be able to collect in-network deductibles and coinsurance and that sort of thing, even though the care is provided out of network. And the plan is going to be required to pay essentially at in-network rates, even though it's an out-of-network provider. And there's some other sort of rules and procedures around this to try to make the payments and reimbursements to the providers fair. Again, this is very new. The idea has been talked about quite a bit, as you may know, for years now, but the rules themselves are quite new. So we're going to be seeing, I think, more to come here in the near future. But just know that that's sort of evolving, and I think we'll see a lot of interest in that as those rules begin to come online starting next year. Last thing I wanted to mention, FFCRA paid leave. Many of you will be familiar with this. As you may know, that those paid leave mandates were allowed to expire at the end of 2020. But were continued on a voluntary basis. So if you're an employer of a size that you were previously required to provide FFCRA paid leave, you can now continue to do that on a voluntary basis. And if you're a non-governmental employer, you can continue to receive a tax credit for that care, that paid leave that you're providing, as well as any healthcare coverage that you pay for while an individual is out on paid leave. So I don't think that's now pretty well understood. So probably not a lot that we need to focus on there. But the point is that it's a voluntary continuation of those benefits here through the end of March of this year, and then we'll see what happens from there. So with that, I think I am out of time, but if there's any questions, I'm certainly glad to try to go through those quickly, and otherwise we'll turn it back over to you, Shelley.
I had one question and we asked it. Does anyone else have a question very quickly? I am seeing none. Well, that was great. You did a great job. You always do. You in a half an hour time, or even less than that, you go through so much. So anyway, hopefully we will hear from you later on, sometime in the summer, and we'll see what else is new by that time. So anyway, Jason, thank you so much. I appreciate your time. That was great.
And that sounds great. There'll be plenty to talk about in 6 months from now as well, I'm sure.
Well,
So.
I actually have lots of questions, but I know we're out of time. So we'll talk later.
Sounds great.
Okay.
Take care. Have a good day, everyone.